Good afternoon, guys. My name is Alina Shaltsova. I'm an immigration attorney from New York. I'm going to be sharing with you today the most recent immigration news. Of course, we're going to talk about America Competes Act 2022. We're going to talk about recent changes related to the work permits, and we're going to talk about immigration courts. Alina Shaltsova. For those of you who know me, thank you and welcome back. Who do not, please join us. Thank you for joining us. Don't forget to subscribe to my channel. I do these live presentations on immigration law regularly. I also post videos and updates on my community board. So say hello, say where you're watching from. Hi, Ronald. And of course, in the end, we're going to discuss your guys' questions. So please save your questions, type them up in the chat. So after I'm done talking, I'll be happy to answer your questions. Hi, Arun. So thank you very much for joining. I see some people joining. And let's talk about the most recent immigration news. Of course, I, like you, probably check the media periodically, and I found out from various media resources that recently the House of Representatives passed what's called America Competes 2022 Act. And it's a massive piece of legislation, proposals. And of course, some of it, the reason why I'm bringing it up today is some of those proposals concern immigration changes, right? Concern immigration changes. And again, it's not the law yet. It's just been passed by the House. And this is one of the things I'm going to talk to you about, what's in it, what's good and what's bad in it for immigration. And first, I wanted to mention just a few words about work permits. Just today, USCIS announced that in response to the, I would say, crisis with the work permits, the fact that you may have to wait for 9 months to renew your work permit, they're changing rules a little bit about the validity of the work permits. And now certain work permits in certain categories are going to be issued for 2 years instead of 1 year, or potentially even longer. So these are going to be the work permits that will be issued for 2 years, in addition to the ones that we already have. If you recall, we already have 2-year work permits in C8 category, asylum pending, in C9, adjustment of status pending. And now the same is going to be applying to those who receive work permits because they were admitted as refugees, A3, asylum granted, A5. And here is a note. Guys, if you are granted asylum in the United States, you don't really need to have a work permit, okay? You are authorized to work in the United States without the EAD, work permit card. It's something that you need to know. You need Social Security card, right? You still have to have a Social Security number and so, but you don't have to file for A5 work permit and waste your money. I don't know why they keep doing that. Keep suggesting that they're issuing these work permits. Perhaps there are situations where you would want it because maybe you didn't receive your C8 work permit when your asylum was pending, right? Imagine perhaps a situation where your case was directed to the court and you never had a chance to receive C8 asylum pending. Maybe that's why. That would be a situation when you're going to go for A5. But generally speaking, if the judge grants you asylum or you receive your asylum from the interview, you don't have to file for the work permit, okay? You just have to update Social Security Administration with information that now you are an asylee in the United States. Also, those who received withholding of removal, and this is important because I know some of you who have withholding of removal are seriously tired filing for this work permits every year. Well, now you can do it every 2 years. A10. VAWA C31. VAWA granted C31. Applicants are going to also receive work permits for 2 years. It's actually good. Why? Some of you may have noticed that you first receive approval for your I-360 VAWA form and you receive this C-31 work permit, but your I-45 green card, if you could file for it, is still going to be pending for considerable amount of time, over a year, maybe even close to 2 years. So it will be good, right, to have a work permit in between. In addition, those work permits, they also serve as a confirmation of the deferral action, which can be very useful for those of you who cannot file for the green cards, but would like to be safe from removal. And USCIS also said that those of you who are going to receive parole for urgent humanitarian reason will be receiving work permits up to the validity of that parole, and those at C11 and those who received deferred action C14 are going. Those people's work permits are going to be valid for the entire time of the deferred action. Good, but I would rather do something that the work permits are processed faster, right? Because what happens? What happens is that, let's say you have this 2-year work permit. Within the 6 months of its expiration, you're filing to extend it. And if the processing times are too long, you're still finding yourself in this difficult situation where your work permit maybe is expired and an extension, if you received an extension, also is expiring and you still don't have your renewed work permit. So while of course it's better than nothing, this extended work permits, I still think they really should focus their efforts on processing applications faster, because we basically are witnessing record high long delays in processing of the work permits. But this is good. I mean, that's better than nothing. Now, let's talk a little bit about the immigration courts. If you recall, immigration hearings for non-detained, unrepresented were canceled due to new COVID wave, up to, I think, today's date. Guess what? Now they're moving forward. Okay, we received an update from immigration courts that hearings are going to move forward. It means that you have to stay on top of your case. Check that calendar in automatic system, and it's still not be accurate. Here is a rule of thumb. If you are in a system and you hear that there is a hearing date, you call them or you check online for you, show up. All right, you showing up there, because there is nothing worse than missing the hearing that was supposed to have happened. It's okay if you show up and the judge says, oh, I actually canceled your hearing. Well, fine. Yes, you wasted your time, but you're not going to be ordered deported. When you don't show up for the hearing that is scheduled, you will be ordered deported by default. And then you'll have to file a motion to vacate and rescind the deportation order or removal order. So always check with your attorney, always check with the court, the system. Hearings are moving forward. It means, from what I understand, they're going to be moving forward in person as well. Will you have an option to appear by phone or video? It depends on the judge. Some judges say you don't need to file any special motions. You can just dial in, or your lawyer can dial in. And some judges say that, you have to file a special motion. You must come in person if you can. Unless you can't, and then you have to explain yourself why can't you, right? So very, very important to show up in court, stay on top of your cases. Extremely important. By the way, February 11th, again and again, I repeat that, everything that you submit to court must be submitted electronically. It's going to be an upload system. Can be good sometimes if you know how to use it, because then the court will not be able to say, we lost your document, you see? It happens sometimes, especially not so much these days. In the past, it did happen to me. All right, so now let's talk about the most interesting topic, right? The most interesting topic is this new law that's passed. Well, project of the law. It hasn't become the law yet. But it's interesting, in fact, in terms that they're trying to reform a little bit immigration system and give a break to some of you. But how and what's happening? So America Competes Act 2022 is the law that actually is designed from what I understand, for America to help America to compete against China. There are many provisions there that they're aimed at this, competition between the two countries. But for immigration purposes, the law contains two main provisions. It provides visas for entrepreneurs, those who have startups. And also it helps those of you who will have PhDs to receive green cards. These are the two main immigration provisions in that act. Similar act was passed by the Senate in June of 2021, but there are differences between these two versions. And now the House and the Senate will be in conferences to basically come up with one version. And if the President Biden signs it into the law afterwards, after it's confirmed and everything, we're going to have new visa. We're going to have W visa. Actually, I would say 3 new visas: W1, W2, and W3. Those visas will be for those who can show that they play active or central role in a startup, where they possess at least 10% of the ownership, and the startup attracted at least $250,000 from qualified investors within the 18 months prior to the person's application for the visa, or $100,000 in government grants. W2 visa will be for those who are essential to support the startup, and W3 for dependents. Good plans. I'm not really sure how many people exactly will be able to benefit from it. I mean, from one point, of course, it's a good beginning to allow active people, business people, to somehow come and work in the United States. But for people who are in the United States, I'm not quite sure you will be able to benefit from it. Visa always implies that you have to file for it from overseas. If you accumulated unlawful presence time, unless the law changes, or you receive a waiver, if you leave the United States, you will be inadmissible to come back for 10 years or 3 years, right? So how will it help for those of you who are here? I'm not sure. I know that there were talks about the United States government starting issuing visas within the United States, so you don't have to leave the United States. And of course, it's just talks. Apparently, there was a practice like this, but it was before my time. Before I became an attorney in the United States, there was a practice. People say, again, that you were able to receive a visa in the United States. You wouldn't have to go to a consulate overseas. Very interesting practice. I know that it's in fact is used in many different countries in the world, including, for example, Russia. You can receive a visa, interestingly enough, inside of the country, or Belarus, but not in the United States. To get a visa sticker, unless it's a diplomatic visa, you will have to be outside of the United States. So unless they do something like that, or they will say that W visa acts as an admission similar to T and U visas, for example, then, of course, people who are in the United States, business people, will be able to potentially benefit from it. Otherwise, it will be only for those who are outside, unless waivers are going to come to play or they're going to change the law. But overall, it's not a bad solution for entrepreneurs. These provisions also say that if your enterprise is going to prove itself to be successful, meaning that you're going to generate 1 million in revenues, or you're going to attract 1 million, I believe 250,000 in qualified investments, you will be able, your enterprise is going to be able to sponsor you as a business person, business investor. I mean, listen, 1 million sounds like a lot of money, but many of you, probably those who have your own businesses, do generate that, right? So qualified investors, again, it's very similar, this rule, to the parole for entrepreneurs. I think they were looking at the parole for entrepreneurs when they were drafting this rule. Basically, it has to be US citizens, people who actively invest, or you need to show that you received grants from the United States government. So basically, you have some serious thing and not just moving money from one account to another. Good provisions again. Unfortunately, of course, they're not going to help everybody. Another important provision for PhD students and graduates. This law aims at providing direct path to green card for those who are going to have PhDs. They estimate several thousand people are going to be able to benefit from it. Good provision. Of course, it should have been done a long time ago. If you manage to receive PhD in the United States, which is extremely difficult to receive, you should be able to stay. You should be able to qualify for a green card, just like it's done in many other countries who really would like to attract talent, the smartest, the most hardworking people, right? So this is what this America Competes Act is about, right? Small provisions may be able to help some of you. We'll see what's going to happen. I don't anticipate that anything is going to happen with it within the next couple of months, or perhaps it will. Maybe they'll try to say this is the immigration reform, which I hope they won't. But this is something to know about and watch for if you believe that you may qualify for it, or perhaps you'll have an opportunity for a waiver, for example. We will know more once these particular provisions will in fact become the law. Then we'll be able to comment as to who can really qualify, who will not, whether it's going to be predominantly for those who are currently overseas, or will be able to be used by those who are here as well. Now let me see if you guys have questions. I'll be happy to answer them. Hi, Ali. Please give us undocumented immigration reform for 11 million of essential workers. I absolutely agree with you. In fact, on April 27th, if everything goes well, and I'll be around, I will participate again in AILA Day for immigration advocacy, that when AILA, American Immigration Lawyers Association, are meeting with elected officials advocating for the reform. Hopefully, I will have some more information for you guys. If by then nothing is done as to when, what, and how the immigration reform will be done. Hi, Obeng, how are you doing? Please, can someone whose asylum proceedings has been terminated by immigration judge without prejudice be able to renew their work permit when it expires? Sweetheart, if your asylum proceedings were terminated, it means you do not have a pending case anymore. Okay? Unless you have a pending case when proceedings are, let's say, administratively closed, then you would qualify for the work permit. I hear some people say that it's possible, but I've never seen it possible, and it's just going to be not logical, okay? Because if you withdrew your asylum case, when proceedings are terminated, you basically tell the judge that you're closing all the pending applications. You have nothing to have this base that you need, the base for this work permit. Nothing is pending. And of course, talk to your lawyer. Maybe there is something else going on there that I'm not aware. Hi, Mimi, watching you from Minnesota. What about essential workers? Honestly, guys, I don't have any specific updates about essential workers at this time. Maybe if you've heard something, please share with me, but I haven't, unfortunately. Hi, Yancy, thanks for sharing. I agree that you need to work on processing work permits faster, right? So instead of processing them faster, they say, here is a 2-year work permit. What is the difference? Then allow me to file for the new work permit a year ahead of its expiration, right? Then it's going to make sense. Otherwise, it just doesn't make sense. You're still in the same situation, only a year later. That's it. Hi, True Wisdom. I really don't want to live in the United States, but visit is I-30 the only way after overstay. Oh, you can file for a waiver. There are waivers for that, right? There are non-immigrant visa waivers, but the problem is this. To receive a non-immigrant visa waiver, you first have to be qualified as a true non-immigrant, that you do not have an immigrant intent. And for that reason, it's hard. There is a very generous, I believe it's 212D3 non-immigrant waiver, waives almost everything. Overstay, criminal grounds, I don't know, short of some heavy, horrible things. But the problem is this: if you go for your non-immigrant visa, consul may deny you, not because of the criminal past or because of overstay, but because they say, well, because you overstayed, now we think you want to live in the United States. You did not rebut the presumption of immigrant intent. And that when you receive this denial, 214B it's called, you can't file for the waiver. If they say, we believe you, you just want to visit, right? But you have this criminal past or you overstayed, then you can file for the 212D3 waiver. That's how it works. For that reason, usually lawyers are going to say, you know what, chances to pass this little hoop are very small. Most likely you will be simply denied on immigrant intent, and you're never going to reach the point where you can file for that non-immigrant waiver. And for that reason, people say that you're going to have better chances of filing for an immigrant visa with a waiver still, if you didn't serve your 3-year or 10-year bars. Hi, Azad. Why is it not working for the people who stuck in backlog for years as affirmative asylum applicants? You know, I just had a little video about that. It's very interesting. Why? Because USCIS took a position that last filed people should be called for the interview first to fight immigration fraud, right? And for that reason, all of you who filed years prior are stuck. Apparently, on average, they're processing only about 30% of all the applications, or applications that were pending for 36 months and longer. And most applications are going to be those who are pending less than for 21 days. That's why. Because they decided, USCIS decided, that this will be better this way. But applicants are being called from 2016 and 15. 15, very rarely you will be pending from 2015. Mostly people who are waiting for their asylum applications will be from 2016, right? Onward, of course, 16, 17. But I meet sometimes people who say they filed back in 2015, but then probably you moved, you changed your state. Hi, Taburang. That's not Biden promised you 11 million. He needs to do something about what he promised. I agree with you. What we discussed is not an immigration reforms that was promised. I said, I hope they're not going to try to argue that it is, but it's a good, it's a good provision for somebody who is an entrepreneur and would like to, just come. I receive millions of phone calls for people who say, oh, I'd like to come and I have this business idea, I may have some investments. And I'm like, okay, but the problem is that currently immigration law has very limited circumstances when you can come here using investments. You either have to qualify for EB-5 and wait for a couple of years, or E2, which is non-immigrant entrepreneur with a substantial investment. And also that's not guaranteed. And some countries, some citizens of certain countries can't even qualify for that because they don't have the treaty that necessary to qualify for E2. So we'll see. Hi, David. I was successful at my adjustment of status interview on December 29, 2020. And in the application, I have 3 children. I filed with it as it was approved. Please, how do I get my children to join me? Well, you see, who filed for you? Just because you received adjustment of status, you may have a couple of options. If you received your green card based on marriage, your spouse may also sponsor the children if they meet the criteria, or you can file for your children I-130s if you are now a green card holder. So you may have some options depending on children's age and your situation. You may choose any of those options, I think you should talk to an attorney. But children will not be able to usually join you automatically unless it was an employment based case, and still you have to then reroute I-140 to the NVC for the children. If it was a adjustment based on green card, adjustment based on marriage filed by a U.S. citizen, each child has to be sponsored separately with a separate I-130 petition from that U.S. citizen. And you have to show that you married the U.S. citizen prior to the child's 18th birthday. Okay, so it depends on the situation. Hi, Arun Kumar. Could you explain more on options available for asylees applicants that have been in the United States for over 10 years? There are no specific options that just because you're an asylee, you're going to have. They don't exist. Also, I've never met anyone who is not transferred to court, who is an asylee, who's going to be pending in asylum process for that long. So usually if you are for 10 years an asylum applicant, it would mean that perhaps you are in removal proceedings as well. And there will not be any universal solutions here. Means that you may be able to adjust if you're, let's say, a spouse of a U.S. citizen, you have a real marriage, and you can show that you entered the country with inspection or parole. You perhaps may qualify for some humanitarian options like VAWA or U visa, but there are no some universal options, unfortunately. United States law or immigration laws are generally not generous and kind of very hard to meet the requirements in general, I would say. So I know many people would like to come here, and they're promised by some people who are advocating for them coming here that somehow you will be able to stay and work and so on and so forth. But once you file for that asylum, you see it's not easy to win it, right? It takes years. You have to have very strong case. You have to remember everything. Because when you go for court hearing, you can't just sit there and say, oh, I don't remember. It's been 10 years ago. It's expected of you that 10 years later, you're going to remember what is it and when happened to you. So it's an interesting system. Hi, Kareem. I have filed motion to reopen for denied H-1B. What is chances of approval and what's the processing time for Vermont Service Center? I would suggest to discuss it with your attorney. Each motion to reopen is different depending on why you were denied. Also, I cannot say that there are some general expectations. I mean, your case was denied. Why? What happened? Were you able to address the core of the denial? Did you present that one document that 100% rebuts USCIS claim of your ineligibility for H-1B? Then you have good chances. If not, then it depends on what is it that you're arguing. Processing times are available at USCIS website. Won't even comment on that just because there is so much discrepancy between, sometimes motion to reopen is granted within 30 days, you receive a decision. Sometimes it's going to be pending for well over a year. So really, guys, cannot tell you anything useful here. Hi, Farhan. I want to work as international lawyer immigration. I have also done masters in anthropology. Can I work? Wait, where did you go? Can I work your assistant? Oh, thank you, sweetie. I would say no, not because I do not like you. Absolutely not. It's just because I'm not hiring at this time. But if I will, and you will meet the criteria and you have a work permit, because we all have to abide by the rules here, then you're absolutely welcome to apply. Hi, Gemini. Hi, Miss Alina. Can you help me? I already applied for me and my husband work permit renewal, but it's not coming for 7 months. All right. Now, we had a previous video on this website discussing how someone can expedite their case. On my website, I have very thorough pathway or a roadmap as to how to expedite a stuck case, especially work permit. In comments to this particular video, I'm going to give you a link. And trust me, if you're going to follow whatever is said there in that article, you will be able to get your work permit. Okay, 7 months, it means it's up for renewal, so you should be successful with that. Well, guys, thank you very much. It was a pleasure to meet all of you, and I'm very happy I was able to answer some of you guys' questions. If you like this video, found this information helpful, please like and share it. Don't forget to subscribe to my channel, and I hope to see you soon.